Rule 412, which is also known as the Federal Rape Shield Statute, was enacted in 1978 and originally applied only in criminal cases. In the early 1990s, the Judicial Conference recommended extending the rule to civil cases involving sexual misconduct. The Supreme Court, however, did not approve. The court believed the proposed rule altered substantive rights by making it more difficult to defend against sexual harassment accusations. Congress enacted it anyway, along with various other changes to federal criminal law and procedure in the Violent Crime Control and Enforcement Act of 1994, the largest crime bill in U.S. history. The act fueled mass incarceration across the country, and many of its provisions remain controversial today, including Federal Rules of Evidence 413, 414, and 415. Those three rules are the only ones not proposed by the Advisory Committee. Congress enacted them directly. Rule 412 applies when sexual misconduct is an issue, regardless of whether the claims or charges include sexual acts as an element. For example, it might apply when the only charge is kidnapping if any sexual conduct took place. The rule does not apply to cases involving no sexual misconduct but relating to sexual topics. For example, it does not apply in a defamation action where evidence of the plaintiff's sexual history or reputation is offered to show that the allegedly defamatory statement was true or did not harm the plaintiff's reputation. The rule bars evidence of the reputation or sexual past of the alleged victim of sexual misconduct, except where it has special relevance. The rule reflects the simple fact that sexual activity having no connection to the alleged misconduct is generally irrelevant to whether the acts were consensual. But depending on the testimony in a particular case, it may become relevant. In Sandoval versus Acevedo, for example, the complaining witness made a false claim about her sexual history on the stand, potentially misleading the jury. The Seventh Circuit held that, while the issue was close, the trial judge's instruction to the jury to disregard her testimony on that point signaled to them that she had lied and cured any prejudice to the defendant. In criminal cases, the putative victim's reputed attitudes about sex are never admissible. An alleged victim's particular sexual acts are admissible only to show that the defendant may not be the source of any physical evidence, to show the nature of any existing relationship between the person accused and the purported victim, and when the Constitution requires it. This last provision guarantees that a defendant will have a full and fair opportunity to present evidence and cross-examine witnesses, and always depends on the specific circumstances of the case. The example the Advisory Committee gives is Olden versus Kentucky. In Olden, a white woman named Starla Matthews went to a bar serving a mainly black clientele. She later claimed that James Olden, whom she met at the bar, raped her. She gave conflicting accounts, and there was substantial evidence at trial from disinterested witnesses that Matthews was lying. The defense theory was that Matthews made up the rape to protect her adulterous relationship with Bill Russell. Matthews and Russell were married to other people when the rape supposedly took place, but left their spouses and were living together at the time of trial. The judge refused to allow the defense to cross-examine Matthews about her relationship with Russell, even when she lied on the stand and said she lived with her mother. The jury's inconsistent verdict acquitted Olden of kidnapping and rape, but convicted him of forcible sodomy. The Kentucky Court of Appeals affirmed, claiming that telling the jury that Matthews lived with a black man would have been too unfairly prejudicial. The U.S. Supreme Court reversed the conviction, holding that preventing the cross-examination violated Olden's constitutional right to confront the prosecution's main witness. In civil cases, the rule leaves admissibility to the judge's discretion, but changes the usual analysis. Under Rule 403, the opponent has the burden of showing that evidence should be excluded. Under Rule 412, the proponent has to show that it should be admitted. Another difference is that Rule 412 disfavors admission, while Rule 403 prefers it. Under Rule 403, evidence is excluded only if its probative value is substantially outweighed by another consideration. Under Rule 412, evidence is admitted only if it is exceptionally probative. Rule 412 applies not only to criminal behavior, but also to sexual harassment, which is a civil claim. Whether conduct is harassing is contextual, and evidence of the complaining witness's behavior at work is usually admissible, while behavior outside of work is not. Courts generally recognize that people can expect a professional work environment regardless of how they act outside of work. Rules 413 and 414 respectively allow evidence of other sexual assaults to be used to prove a charge of sexual assault, and evidence of other child molestation incidents to prove a charge of child molestation. Sexual assault incidents cannot be used to prove a charge of child molestation, nor vice versa. To be relevant, the incidents must be of the same nature as the charged crime. Rule 415 makes this same type of evidence admissible in civil cases and adopts the definitions of sexual assault and child molestation given in the two preceding rules. Evidence offered under any of these rules is subject to Rule 403, and some federal courts have suggested that the rules would be unconstitutional if Rule 403 did not apply to evidence of sexual assault and child molestation incidents. However, there is an inherent tension between these rules, which are meant to allow propensity arguments about sex crimes, and the notion of unfair prejudice, which Mitchelson and Oldchief both held is engendered by propensity arguments. In Iowa v. Cox, the Iowa Supreme Court followed the Missouri Supreme Court in holding that admitting propensity evidence to prove a child molestation charge violates due process. That remains the law in Iowa, but Missouri amended its constitution to overrule its Supreme Court on this issue. The majority opinion begins by distinguishing cases involving evidence of uncharged sexual acts with the same alleged victim. The court later reiterates this point and explains that such evidence is relevant to showing the nature of the relationship between the people involved in the case. Remember that Rule 412, the federal rape shield law, similarly allows a criminal defendant to introduce such evidence to show consent. The court's analysis then explains that federal courts, as well as some state courts, view Rule 403 as obviating any due process problem. The court proceeds to examine both the rationale and the basis for excluding propensity evidence under Iowan common law. Finally, the court explains why the federal courts are wrong to conclude that allowing this evidence does not violate due process. The meaning of unfair prejudice in Rule 403 includes, as Mitchelson and Oldchief both hold, the invitation to infer guilt from similar uncharged acts. Denying that violates the principle that common law terms used in a statute carry the same meaning they had at common law. In other words, the federal courts are wrong because courts can't change the meaning of unfair prejudice. That is a legal term whose meaning was fixed no later than when Mitchelson was decided. The difference between propensity evidence and habit evidence is that propensity evidence relates to character, and character has a moral dimension. There are good character traits and bad ones, but by definition, there are no neutral ones. Character is a person's moral fiber. Evidence of it is barred because it creates a risk that the jurors will react emotionally to it. They might dislike, distrust, or fear the defendant. Habit evidence does not inspire an emotional response. In its most basic form, this rule allows witnesses to testify about things people do without thinking, and thus may not recall, like locking the front door, driving the same route every day, or putting on a seatbelt. Confined to its least problematic scope, the word habit, as used in the rule, should not cover volitional acts, those that require a conscious choice. It is most useful as a way to supply evidence about an act that a witness can't recall, specifically because it is so routine as to be second nature. Kentucky was the last state to bar habit evidence. The Commonwealth adopted a version of Rule 406 3 years after Burchett v. Kentucky was decided. The three opinions in this case illustrate the dangers of calling any conscious or volitional choice a habit. The majority points out that, even though George Burchett drank every day, he didn't drink on December 12, 1997. The fact that he usually smoked a joint every morning was nonetheless held against him as evidence that he smoked on that day. Burchett, however, claimed to remember not having smoked that day. In the majority's view, calling that a habit created so many collateral issues to explore that the end result was confusion rather than clarity. The further habit gets from reflexive or unconscious acts, the more problematic it becomes. The concurring justice preferred a narrow definition of habit, but did not specify whether he would limit habit to only reflexive or unconscious acts. The dissent's analysis is flawed. It takes Burchett's statement that he smoked marijuana every morning literally. As the majority points out, because that statement is not likely literally true, it does more to confuse the issues and prolong the trial than it does to clarify whether Burchett smoked that morning to allow this in as habit evidence.